Just like on the street with the police officers, suicide by cop is not reasonably foreseeable, nor is suicide by citizen's arrest. When Mr. Arbery turns towards Mr. McMichael, that is an intervening circumstance that breaks any causative chain here with respect to the shooting and death itself. Likewise, and I'm certainly not taking sides in this. It'll be for the jury and the court to determine the guilt or innocence of the McMichael defendants. But at the same time, you have a second intervening factor. The first intervening factor is Mr. Arbery pivoting to the left instead of heading for the exit. The second intervening factor is Travis McMichael discharging his weapon. And I'm not questioning why Mr. Arbery is doing what he's doing. I'm not questioning why Travis McMichael is doing what he's doing. But what I'm saying is you have a second intervening factor, which is the choice of Travis McMichael to discharge his weapon. It doesn't really matter for purposes of evaluating count one malice murder if the court can see that whoever's in the right here, whoever's in the wrong, whichever party is using excessive force, maybe both parties are using excessive force, maybe there's some kind of mutual combat theory to be had out there. But from Mr. Bryan's perspective, in terms of proximate cause, in terms of what's reasonably foreseeable to him, none of these things are reasonably foreseeable. And I think the court understands the consequences if the court were to go down any other road. And if we're going to persist with this issue, we're going to wind up in a severance posture. It may be premature. We haven't heard whether any of the other defendants have testified yet. But I would submit the easiest way to resolve the severance issue is to grant the motion for directed verdict for Mr. Bryan as to malice murder. Moving on to count 2, felony murder, which is tied to count 6, aggravated assault.